Hello, good day to Sir Shafiq. We are from Group 9, about to present the case of immunities and criminal proceeding between Equatorial Guinea against France. So here is our theme, myself as NOOR Afiqah Hanim binti AMRAN, together with my partners KHAIRUN NISA binti Muhammad NOOR and SHARIFAH NABIHAH binti SYED. So the dispute involved Equatorial Guinea and France, actually starting when Mr. Teodoro, who is the Equatorial Guinea's second vice president, was granted diplomatic immunity, and the building at the 42 Avenues Foch in Paris was declared as the state's property by the International Court of Justice on 11th December.
Assalamualaikum and a very good day to Sir Shafiq. My name is Sharifah Nabiha, and right now I'm going to explain about the facts of the case, the ratio descendendi, as well as the dicta of the case for Equatorial Guinea against France. So first of all, for the facts of the case, the Association Transparency International France had filed a complaint against the particular African head of state on 2 December 2008, following the claim of them swindling the public funds of their country and later using the funds to invest in France. And the claim had been validated in the French courts, and judicial investigations had been proceeded in 2010 for the case in respect of handling misappropriate public funds, with other criminal allegations such as money laundering, breach of trust, and concealment of these offences. Actually, the investigation was more focused on the ways they acquire all the movable and immovable properties individually, especially the son of President of Equatorial Guinea, Mr. Teodoro, who managed to acquire all kind of valuable items and even a building at 42 Avenue in Paris. However, they claim that the embassy used the building for years in performance of diplomatic missions, but then the protocol department of the French Ministry of Foreign Affairs stated otherwise, and that the building is actually not fall within the premises for diplomatic mission, as Equatorial Guinea claimed. So the case continued for the court to decide the legal status for the building located at 42 Avenue Foch in Paris, whether it is considered a property for diplomatic mission or it is considered as state property.
Assalamualaikum warahmatullahi wabarakatuh. My name is KHAIRUN NISA binti Muhammad NOOR and my matric number is 054917. So, the issue regarding this case is whether building at 42 Avenues Foch is part of Equatorial Guinea's diplomatic mission and whether the French Republic violated the international obligation owed to the Republic of Equatorial Guinea. In this case, since the Avenue Foch property had been transferred within the framework of that convention, the term premises of the mission was never used. The ICJ realized that it fell within the scope of Article 1 of the Vienna Convention, which stated that a property cannot be designated as premises of the mission when a receiving state objects to the classification of a property as part of a foreign diplomatic mission headquarters. This signifies that as long as the French objection was timely communicated and there were sufficient ground for France's non-arbitrary and unbiased objection, the court allowed France's objection. According to the court, these conditions have been met by France's objection in the current case. The objection was considered non-discriminatory since France did not treat another country favorably if they were in the same state. Moreover, the court also considers that Equatorial Guinea was not denied their diplomatic premises in France, notwithstanding the French government's objection to acknowledge the former location as premises of the mission. Equatorial Guinean officials failed to get the requisite consent for 42 Avenues Foch as the premises of the mission, since their objection was deemed justified. France consistently opposed to the idea of identifying the Avenue Foch property in Paris as diplomatic premises, and it was determined to satisfy all of these qualifications. Despite this, the decision was not unanimous, with 7 of the 16 judges disagreeing. Even so, it was agreed by the majority that the receiving state should not be required to follow any designation made by another state as to its diplomatic premises.
So move on to the ratio decidendi of the case. In order to interpret the meaning of premises for diplomatic missions, the court referred to Article 1, Clause 1 of Vienna Convention, which stated the definition of the expressions, but actually the provision was silent about the roles of the respective countries as the sending or receiving states in the designation of mission premises. And then Article 2 of the Vienna Convention stated that diplomatic relations must be formed based on mutual consent. Still, the court viewed that it is difficult to acquire a building as the status of the mission by unilateral designation. The court also emphasized on the preamble of the Vienna Conventions that any privileges should be benefited for the diplomatic missions and not individually in order to avoid any abuse from the members, where the statement was also used in the case of United States of America against Iran. The court concludes that they need to decide whether or not the Republic of France against to let the state property become the premises for diplomatic missions, and whether the objection is done in a timely manner within the meaning in Article 1, Clause 1 of Vienna Convention and non-discriminatory in character. So following the analysis of the facts of the case, the court then decided that France's objection was in a timely manner and non-discriminatory in nature. So for these reasons, the court made a decision that the building at 42 Avenue Foch in Paris was not within the status of premise of missions as defined in Article 1, Clause 1 of Vienna Convention. Next, for the dicta of the case, in regards to the case, the court made their decisions by using certain provisions from the Vienna Convention, United Nations Conventions, together with the rules of court in respect of the methods used for proceedings. Firstly, the court referred to Article 35 of the United Nations Convention against Transnational Organized Crime, and later continued with Article 1 of the optional protocol to the Vienna Convention, which mentioned matters concerning the settlement for this, diplomatic affairs. So after the first submission of requests by both parties, the court ordered France to take all measures to treat the building at 42 Avenue Foch in Paris so it could be used for diplomatic missions pursuant to Article 22 of the Vienna Convention on Diplomatic Relations. Then, on 5 April 2017, after France submitted their preliminary objections, according to Article 79, Paragraph 5 of Rules of Court, proceedings for the merits were suspended and Equatorial Guinea could submit their sides for preliminary objections as well as their written statement of observations, followed by the French Republic. And so the next procedure taken by the court was stated in Article 53, Paragraph 2 of Rules of Court, which is to submit their copies of documents and pleadings to be accessible to the public for the oral proceedings. After that, both of the parties submitted their requests to the court.
Regarding this case, there are many different views from the other judges which oppose to this decision. Firstly, President Yusuf in opinion that the necessity of prior consent or the ability to object by France as stated in the ruling has no validity in the wording of the convention. Vice President Zhu added that the transaction between France and Equatorial Guinea concerning the purchase of the building was legal. Therefore, the consent of France was not required and Equatorial Guinea had the right to designate it as it wished. Moreover, Judge Gajah also declared that consent is not necessary in the much more frequent case of buildings situated in the capital city. Moving on to the next view from the judges, the Judge Sebutinde focused on the test that the majority accepted inevitably points to the fact that a property might not ever acquire diplomatic status alone without consent of the receiving state. However, it could not be found in customary law or the Vienna Convention, and the majority rejected this argument. Meanwhile, Judge Robinson contended that the building did have the requisite status under the convention by inspecting the evidence provided. Finally, Judge Ad Hoc Katekato disagreed with the decision concerning the requirement of the consent and argued that the use requirement in Article 1, which is respectively provided, has been disregarded.
Okay, let's have a look at parties' argument, starting with Equatorial Guinea. The property at 42 Avenue Foch in Paris is not protected by law since it is not a part of Equatorial Guinea diplomatic post in Paris, so it is written already to the Mr. Teodoro as the country's vice president. He is protected under international law, as we know that the vice president is a constitutionally important executive branch position, so that Equatorial Guinea adjudged the building to be officially recognized as Equatorial Guinea's official residence or property. And when it comes to diplomatic missions, Equatorial has made it clear to French government that Vienna Convention is declarative in this kind of respect. Okay, now let's move on to France. According to French investigators, Mr. Teodoro has been in South African custody since 2006, and he has admitted that Equatorial Guinea cabinet members established and owned foreign companies to get government contracts, and the Swiss and French authorities were has checked between Mr. Teodoro and the mansion at 42 Avenue Foch, where he is suspected on money laundering, and the court tried to uphold the standard of sovereign equality, non-inter and other nation internal affairs. However, Equatorial Guinea's request was denied because the country lacks of jurisdictions, and there is no clause that will be enabled for the court to adjudicate on this concern. As stated in the Article 4, the Parliament Convention actually is not meant to protect the sovereignties of the state parties.
First of all, due to this conclusion, many states' practices and rules have now become inconsistent with what is currently understood about international law. The details of this case were unusual and uncommon to occur often. Nonetheless, there was no proof that Equatorial Guinea had utilized or planned to use the property for diplomatic purposes. In addition, during the stated period, Equatorial Guinea had preserved other diplomatic properties in Paris. The court believed that France's objections were not arbitrary or frivolously done in light of this. Therefore, it was implied in effect that the designation was not valid and that the use of Equatorial Guinea's diplomatic powers to avoid an investigation had been made in violation of such rights. In the end, the verdict has not had a significant impact on diplomacy. There is no denying that it changed things up a bit. As we can see, the receiving states have the option of objecting if they believe that a designated diplomatic facility is being misused. That was a good thing because it maintains that international law is balanced, as the court put it, fair and beneficial to all parties, even if it is not a subject of treaty interpretation.
Thank you, Nisa. So let me continue this presentation again. Because Equatorial Guinea has not relinquished its customary international law immunity, France has no jurisdiction to forbid Equatorial Guinea from owning the building 42 Avenue Foch. In accordance with international law, France must ensure that no restriction on the state's property are used without approval, where France already breached on this. And states' immunity from the attachment of their property is codified in the 2040 of UN Convention on the Jurisdictional Immunities of States, which represents customary international law governing countries' immunity from the attachment of their property. conclude is doesn't matter who owns the building as long as the property title has been transferred to French government. Thus, the property was never been awarded that status as claimed by the Equatorial Guinea. Hence, Equatorial Guinea cannot claim any benefits. So that's all from us. Thank you.